Welcome to Disunion, the Government Union Report, the podcast where we delve into the ever-evolving landscape of public sector labor policy and law. I'm your host, David R. Osborne, and I'm excited to be your guide through the complex world of government unionization. We bring in experts and individuals with hands-on experience navigating the challenges and opportunities surrounding the unionization of government employees. From the latest legal developments to the practical insights that shape the policies, we've got it covered. So get ready to gain a deeper understanding of the newsmaking issues that impact public sector labor policy across the nation. My guest today is Nathan McGrath. He's president and general counsel at the Fairness Center. Prior to that, he was staff attorney with the National Right to Work Legal Defense Foundation, and also served as an associate attorney with Lawler & Lawler in Pittsburgh, and received a law degree from Regent University in Virginia. So the reason I asked Nathan to come on today is that it's a very interesting case in which he's counsel, and I think it's clear that you guys did all the briefing, right? We know that. But you did it alongside National Right to Work Legal Defense Foundation.
That's right. They're co-counsel in our case. Yep.
And now that's proceeded through the district court, the circuit court, and now you have a cert petition filed with the U.S. Supreme Court. Now, I thought this was kind of an important time because initially the opposition, I'll say the name of the case here in a minute, but the opposition did not file any response briefs to your cert petition. I thought that happens all the time. Usually the U.S. Supreme Court denies cert because most petitions are denied. But this time, the U.S. Supreme Court actually required the union and the, I guess the state as well to file something.
Yeah, that's right. Yep.
So, that means they're at least interested. It doesn't mean that a cert petition is going to be granted here, but they're interested in the issue. I am too. And so I wanted to talk about it during this very important time in the history of the case. So what's the name of the case? And then tell me kind of briefly what it's about.
Right. So the case is Goldstein v. PSC. PSC is the union. They represent, or they say they represent the 30,000 professors in the city university system for New York City. It's a large city university system, many campuses, and PSC is their exclusive representative there.
Professional Staff Congress?
That's right. Yep.
Okay.
Yep.
All right. So what's the case about?
So this case comes to us where these professors, we have 6 clients, 5 of them are Jewish professors, and most of them got really frustrated and angry at the union. I guess you could say the last straw was back in the summer of 2021, where the union put out a resolution that was, in their opinion, very anti-Semitic, pro-Palestine, calling Israel an apartheid state, those types of things. And so they came to us and they wanted to get out of the union. They did. They resigned from the union. But then they said, well, but because of exclusive representation, the union still speaks for us, and they're there when we get in trouble, and we're supposed to rely on this union to negotiate terms and conditions of our employment, even though publicly they come out and basically say they hate us and all that we stand for as Zionists. And so we want to be even further away from them. How do we get them to stop speaking for us? And, the answer to that is, well, New York law allows them to be your exclusive representative, and you must accept their representation. So really, to get out from under that, you have to challenge that law.
Okay, the exclusive representation law.
That's right.
So this may be a little pedantic for you, but I think it's an interesting thing. Make sure we cover it. What is exclusive representation?
Yeah, I mean, exclusive representation pretty simply is that whoever is the exclusive representative, in this case, the union PSC, they are the only ones that can speak for the employees in a certain location. Say it's called a bargaining unit technically, but it's basically like the group of teachers, the group of professors, the group of cafeteria workers, that the union is the only one that can speak to their employer for them. So in a normal setting, if you want a raise or if you want an extra day off, you go to your supervisor, your employer, and you're allowed to negotiate with them. You can actually speak to your employer about those terms. When you have an exclusive representative, you can't. You have the exclusive representative that they make the agreement with the employer, And then you're bound by that agreement. It's actually a contract. And so you can't go outside of that contract. And then if your employer, you think, violates that contract, say they promote someone in a way that you don't think is how the contract says they should be promoted, well, you have to go to your union and ask the union to enforce the contract and to make that right for you. So basically your voice has been taken away, your ability to talk with your employer on all these really important things that matter to your livelihood and your family and your life. That's all been handed over to the union.
Got it. So we're still defining terms here.
Okay.
But I get people asking all the time, especially lawmakers, why don't they just resign their union membership? If they're no longer a union member, what's the problem? I know the answer is exclusive representation, but explain why that situation is still problematic.
Even if they're not a union member, and people are like, oh, great, they're not a union member, they don't have to pay the union dues anymore, so that must solve it, right? No, actually not, because merely being an employee in what is the bargaining unit, that subjects them to the union's authority and power. And so how that really starts is, say you have a new school district and, you hire 100 teachers there, and the teachers union that kind of covers that area says, well, we want to represent those teachers. So they go in and they have an election, and the state labor board allows them to do this. And they go in and they get the majority of teachers who vote that day, typically, to vote yes for them. So if only 10 teachers vote that day, as long as 6 of them vote yes for the union, those 6 teachers vote in the union to be the exclusive representative of all of the 100 teachers, even though the other teachers didn't vote for this union. But now they're under the union's authority, and the state labor board does what they call certifies the bargaining unit. So, and they say, we agree that all these 100 teachers are now under this union's authority. And now the union gets to negotiate the terms and conditions of employment for them, and is their sole representative to the school district for them. So even though the other teachers aren't union members, they're not paying union dues, they never voted for the union, they now are subject to everything the union wants to do for them with collective bargaining.
So that's a really helpful example, I think. I think it would still be problematic, even if there was 100% turnout for that union election, the representation election, and let's say 5 or 6 people voted against the union, but the union became the exclusive representative. They're still bound by there's still necessarily some coercion of a minority,
right?
Even in that highly union-friendly sample that we've put together here.
Yeah, exactly. And there's no way for those, say, in your example, 5 to 6 teachers to say, hey, I have religious objections to what the union talks about or what they say, or I have issues with what they're collective bargaining into our contract. Doesn't matter. Their only recourse is to leave, literally leave their job and go somewhere else.
Okay. That's interesting. I was speaking with someone else, Miley Smith over at Illinois Policy Institute recently, about the language in many of our statutes or constitutional provisions on labor. And many of these talk about people having a right to a representative of their own choosing. Right? You've seen that language?
Yeah, it's sometimes included. Yeah.
Yeah. So sometimes that language is still sort of an abbreviation for you get a union and the right to coerce this minority,
right?
As a part of that, as a function of that. And many state laws, I remember James Shirk writing on this years ago. You could Google that. And he used to write about this for Heritage Foundation that one could still organize a union as a members only union. But as far as I read most state statutes, it talks about the union being an exclusive representative. I don't see any other option other than that. Is that how New York's law reads?
Yeah. And so when there's an exclusive representative provision basically in the law, as soon as the union becomes certified as the exclusive representative, the employer can get sued for dealing with any individual or any members only sort of union, the exclusive rep can actually bring an unfair labor practice charge against them and say, no, we were certified. The state recognizes us. We are the only ones you get to speak with. And so once they're in as the exclusive rep, that's a done deal. They're the only ones that get to speak.
All right. Now, I know that New York also has a little twist on exclusive representation that's kind of different from the rest of the states, right? Can you remind me what that is?
Actually, one of the things that made this case interesting to us, the Goldstein case, was going way back in the folklore, basically, of exclusive representation. It first came out of a case in 1944 where the Supreme Court said for members and non-members of the union, as long as there is an exclusive representative, you have what's called a duty of fair representation, meaning you can't discriminate against anybody. That's right. Yeah. The union has the duty of fair representation because you speak for all these people, whether they're union members or not, black or white. Racism was at the issue of this case back in 1944. Doesn't matter. You have to give them equal representation because you're the only ones who can, basically. And so that's when the Supreme Court blessed that. But all through the case law and the history of exclusive rep, the Supreme Court has also recognized, this is kind of an impingement on your First Amendment rights. We're basically forcing you to give up your speech and accept the speech of another, to be associated with another. And as recently as the Janus decision in 2018, again, the Supreme Court reiterated, got it, it's an impingement on your First Amendment right, but we're going to look the other way, basically, and let this go. We've blessed it. And it's because they also said, along with your exclusive representation status, is this duty of fair representation. And what the New York law basically did when they amended their law, they basically said, all right, union, you have all these duties to your bargaining unit, both union members and non-union members, but we're going to make it easier on you if they're non-members. You really shouldn't have to do such a good job for them. And we're actually going to peel back your responsibilities that you have. And so that's why we looked at this case and we said, well, now this is interesting, because when the Supreme Court originally envisioned this, they envisioned it with this whole list of duties, basically, that the union would have. Now New York's starting to pick off some of those duties. So would the Supreme Court still bless this? Even though it's kind of a slimmed down version of the duty of fair representation.
Mm-hmm. So they still have all the power of exclusive representation under New York state law, and yet the duty of fair representation does not include certain features that we would normally expect from our unions.
Yeah, that's exactly right. It has to do with like the grievance process and those types of things. So, but that's actually not as much part of the case anymore going up to the Supreme Court. The Supreme Court case more is about taking a look at exclusive representation kind of more holistically and not so much specifically as to the certain components of the Taylor law.
Gotcha. Okay. Do they factor in terms of like, does the state have a compelling interest or something like that?
No, not really anymore. So, that was dealt with at the lower court level. It's really, the question is squarely, it does a case from the 80s, actually, the Knight case, is that controlling now on the exclusive representation? Does it basically, was it the Supreme Court's blessing again that exclusive rep is okay? Or does this situation, and what we would argue is that our clients, our professors now are enduring, horrific anti-Semitism and truly a union that hates who they are religiously and their beliefs and all these types of things. The Supreme Court, we think, never really anticipated this and envisioned this all the way back in the day when they said exclusive representation is okay. And because the union now is speaking on so many more things than terms and conditions of employment. That's what people typically think about when they think about a union. They think, oh, it's just, good wages, PTO time, health care, that type of stuff. But our professors union is speaking on, the Middle East and all sorts of things. And I had to chuckle because I was even reading the transcript from our oral argument at the district court level. And at one point, while I was engaging with the judge even said, like, what does the union have any business popping off about things in the Middle East? And I wanted to laugh and be like, yeah, it's a great question, Your Honor. You should ask the other side. Like, I don't know what. And that's exactly our client's point. Like, we're not paying you. You're not here to engage with Middle Eastern politics. You're here for the 30,000 professors in New York City, and you should be getting them the best wages and working conditions possible. Why are you talking about Hamas and Hezbollah and all that in the Middle East?
Yeah. Well, I mean, then I could think of something else that the U.S. Supreme Court may not have anticipated back in 1944. This is a public sector union.
Right. Yeah.
The private sector unions, I guess if they get out of their lane and they start talking about stuff like that, one can be made to join a number of organizations, private organizations. But when the union that you've been made to join or to be represented by is also speaking with a public employer, it seems like everything there would be political. Not just the Hamas stuff, but everything else too.
So the Janus decision that I referenced earlier in 2018, that was getting rid of people who were in this bargaining unit that we were talking about, but who weren't members of the union. They used to have to pay. And the old thought was, well, they're only going to pay the portion that goes to collective bargaining. Mm-hmm. The percentage that is calculated that goes to politics and those types of things, they don't have to pay. Now, the funny thing is it's like the fox guarding the hen house, because guess who got to calculate that? Well, the unions themselves were the ones who came out and said, oh, well, we spend, 80% on collective bargaining and only 20% goes to other types of things. And there were a lot of lawsuits over like, well, what's chargeable, what's not chargeable, what really is politics, what isn't politics. And the Supreme Court in Janus finally realized you can't do line drawing on this, because all of public sector union collective bargaining is political, because at the end of the day, you're deciding where taxpayer dollars go. You're deciding policy in the public interest type of way. You have politicians, elected officials making these decisions with these unions in collective bargaining. So it is actually all political. And that's what the Supreme Court finally recognized in the Janus decision, just saying, listen, this is all political. Everything you do, that's why you don't have to pay. I think it's a logical step then for our clients to now argue, well, if in Janus you said non-members don't have to pay because this is all political, everything the public sector union does in collective bargaining is political, well, then maybe you should go the next step and say, anytime we're forced to accept the union's speech or be represented by the union, that's all a political act too. You're compelling us into certain political positions and arguments. And so I think it's really a logical extension of the argument and the underpinnings that we see in Janus to extend it then to exclusive representation.
Tough question. The case that's standing in your way, you mentioned, is Knight, K-N-I-G-H-T. Right?
Mm-hmm. That's correct.
What did the U.S. Supreme Court say there, and why is it in the way? I mean, how does it justify exclusive representation if now they're kind of criticizing it?
Yeah, I mean, I'm kind of befuddled by this, honestly. I don't understand why this is the case standing in our way, but it is, and it has been for years when people have challenged exclusive representation. But what happened in that case, also a case with professors. You had a number of professors who they were same situation, represented by a union in a collective bargaining situation, but their situation was different. They, at the end of the day, what they were trying to do is get a place at the table. They wanted to be in these negotiating sessions with the union. And
the employees did.
Yeah, the employees did. These professors did. And they said, we want a seat at the table, basically, and we want our employer to have to listen to us. Mm-hmm. And the holding in Knight, if you look at it, it's very narrow. And what it says is that basically you can't force your employer, the government, to listen to you. End of story. That was the holding. And over the years, somehow that's been taken as a blessing on all of exclusive representation. So what we say often is that while the Supreme Court in that situation may have said, the argument in Knight and what the professors wanted to do there, that was not necessarily a winning argument, but that was just one part of exclusive representation. That was just one of the, quote unquote violations that could have occurred in exclusive representation. Our clients claim they don't want a seat at the table. They don't want to be spoken for. It's totally different. It's almost opposite. They don't want the union speaking for them. They don't want to be associated with it. They're not trying to get a seat at the table. They're trying to get away from the table, in fact. And so it's the total opposite. And so our clients' claim is of a different nature of exclusive representation. And really, we think that Knight doesn't give a rubber stamp total blessing across the board to any type of injury that could arise out of exclusive representation.
Well, this would be a good time, I think, to transition to, what does life look like if the U.S. Supreme Court takes this case and your clients get their way? I could imagine a lot of union executives, maybe public employers, who would say, no, we like collective bargaining because then we can wrap up all these people's terms and conditions of employment. We don't have to deal with individuals.
Right.
So how does it look? I mean, what is it, a Wild West kind of situation here?
Well, no, I don't think this is disaster for anybody on any front, really. So if the Supreme Court were to take our client's case, certainly at issue is exclusive representation itself, whether that's constitutional or not. And the Supreme Court could say exclusive representation is unconstitutional and we're not going to have it anymore. But what would happen there is just that then people would either be able to represent themselves with their, to their employer. They'd be able to form, members only, kind of what you were talking about earlier, members only unions, where you could have a union and those 80 people that were in the union want to be in the union and want to be represented by that union. You don't have anyone being compelled in any way, shape, or form. And so you would have that. And really, interestingly, the unions try to say oh, it would be a disaster and, this would be so difficult. Well, public employers, only a third of the public employee workforce is unionized anyway. And so you have a large percentage, they're not unionized. And so public employers deal with non-unionized people all the time. They know how to do this. The system's set up. HR knows how to handle it. Payroll knows how to handle it. This is not a new thing. And so people being able to represent themselves would not be the disaster that the unions say it is. The sky is falling. You get rid of unions and it's total chaos. No one knows how to handle it. Completely false. Another position that the Supreme Court could take is say, well, we're still going to allow for exclusive representation, but those in the bargaining unit are allowed to step out of the bargaining unit and then become like an at-will employee, which again, the public employer totally knows what that's about, how to handle it and how to deal with that. Even in collective bargaining units, you have confidential employees, you have, managers, supervisors sometimes that are exempt from the bargaining units and in certain workplaces anyway. So again, all of this happens. Payroll knows how to handle it. HR knows how to handle it. Everybody knows how to handle this situation. So again, it wouldn't be the disaster that the unions try to say that it would be. And so that in that way, the Supreme Court could really kind of go two different ways, but either way they would go on that, should our clients win, basically it's giving freedom to employees, the right to choose who speaks for them, who doesn't speak for them, and whether they want to speak for themselves.
Yeah. There are employees, you make a good point about the management level or confidential employees. I mean, some employees move in and out of those statuses. So it's not just that you hire somebody and they're a non-union employee. They can get promoted to such a degree that they suddenly are management. They switch sides on the table.
Exactly. Yep.
So the employer might come up with some sort of a pay grade kind of thing. The federal government has some pretty strict guidelines on pay. There are still unions in their lives, but they don't negotiate that. If someone's not unionized, which there are plenty of federal employees who are not, they simply slot them right where they're supposed to be. GS 10, GS 12, whatever.
Yeah. I mean, I've had a lot of friends who worked for the federal government. They're not unionized, but the federal government says, if you want to work for us, here are our pay grades, and we see you as a GS whatever, and that's what you get paid. And if you want to work there, that's what you accept.
Yeah, Walmart would do the same thing and come up with a certain, this is our hiring rate here. They have the flexibility, given that they can make it up as they go, to change that from time to time. Mm-hmm. If the labor market's particularly difficult, they can actually increase wages. If they're in an environment where, I don't know, standard of living might be lower, cost of living might be lower, they can offer lower wages in a particular place.
Take our professors, for example, where the union and frankly, the administration on campus too has made it so hostile and so miserable to be a Zionist, to be a Jew. And if the unions are allowed to harass and make situations horrible, not represent people well based off of them just not liking them or a position they take, what you're going to start to see is that anybody, take teachers and professors, for instance, teachers and professors that aren't willing to walk the party line, to be in the political position that the unions want them to be, to support the people they want them to, all these types of things, are going to start ending up with a choice to make. It's going to be, do I stay and just basically endure it, or somehow go deaf to it, and just take my licks? Or my only way of escaping, because the union is the only one who can speak for me and is my representative, my only way of escaping is to leave my job and to do something else.
Right.
In a couple generations, maybe not even a couple, maybe in just one generation, the only people you'd have left as teachers and professors are people who agree with whatever agenda the union is pushing. Mm-hmm, mm-hmm. And doesn't matter left, right, Democrat, Republican, that doesn't matter. The point is that this situation, this system can really purge all of the teaching ranks of people that they don't like, that they don't like their position on different things. And I think that's scary. I don't think we should be supporting a system like that. That's our clients certainly don't think that, and they're feeling that pressure.
I want to return to something you said earlier. So, the U.S. Supreme Court could, you said, address exclusive representation itself, a broad sweeping decision that says no state in any part of America can have this particular kind of law. Could they also, though, treat this as something like a reasonable accommodation? You've got an objector, maybe not a religious objector, but someone objecting on one ground. Could there be kind of an exit ramp for individuals like your clients in this case?
Yeah, I think that could be like the second option. If you're not going to take all of exclusive representation down like our clients are asking for, kind of the fallback position would be like, okay, we're going to keep the structure in place, but if you have some sort of, objection, you can actually step out of the bargaining unit and leave and not be represented by these folks.
So I'm just thinking through it now, but that would keep the idea of exclusive representation in place in the sense that there's only one union. Now you've still got, I guess your clients could negotiate separately from the union. In that sense, it's not exclusive, but on the other hand, you don't have what I think was the original purpose for exclusive representation, at least the stated basis for it, was you had rival unions coming in, each trying to get time with the employer, mm-hmm. each claiming to have a majority of the bargaining unit and undercutting one another at the same time. And that was the union's interest anyway.
Right.
But,
you had this union warfare basically going on. And so the solution to that in a way was, well, only one union gets to rule. Whoever gets elected gets certified by the state as the exclusive representative. They're the only ones. Everybody else stays away.
Is it also possible for a state, let's say exclusive representation is annihilated in both senses? So not only, is there just, not only can employees go directly to the employer if they've objected on some basis, but you could also have several unions, members only, people are voluntarily part of it, maybe more like a trade association. Could a state give them the right to meet with the employer and the employer would have to listen to them?
Yeah, I mean, I think that you could make a system where it's if they were certified as a union for a portion of the bargaining unit or something like that, that if they had a certain percentage of the bargaining unit as membership or something like that, that they would be given the right to negotiate with the employer, and the employer would have to negotiate in good faith with them, just like the employer is required to do right now with the exclusive representative union. So for instance, that's one of the consequences, and that's really one of the reasons why the unions really want to be certified as the exclusive representative, because they can drag the employer to the bargaining table and say, no, you must negotiate with us and you must do it in good faith. And if you don't, we get to sue you.
Yeah. That, and they've got the spigot, they've got control of the spigot of the labor force. So if COVID hits, the union can basically unilaterally withhold labor from the employer. Exclusive representation allows them to do that. The few people who are non-members could show up to work, right? But because the union represents so many people and there's only one union, they've got a lot bigger voice than one individual.
If the union calls a strike for any reason, they just wield a lot of power, and that really is the driving motivation, typically, I would think anyway, for a union to want to be the exclusive representative and even endure the fact that some people aren't union members. Yeah. It's weird, right? If you had a private business, why would you want to provide services to people who aren't paying you?
Right.
That doesn't make any sense. But unions, these public sector unions, even after Janus, where the Supreme Court said people who aren't members of the union don't have to pay you anymore, unions still wanted to maintain their position as exclusive representatives, even if it meant they had to represent people who weren't paying for them. Mm-hmm. Why? We can only speculate, but it seems likely it's because of the power and authority they have as the exclusive representative.
Well, having known some employees in New York, one of the ways that this particular twist on exclusive representation worked out in practice was that unions would be able to say, look, we made all the rules in the collective bargaining agreement. You're going to have a really hard time filing a grievance and getting through it. Mm-hmm. They're short turnaround times on many of the briefing schedules in the grievance procedure. The union's been through it a bunch of times. They have representatives who are very familiar with it. And, we set them up that way. We don't have to represent you in the grievance under the Taylor law, but you still have to go through it all yourself.
Right.
And that seems like a particularly strange way to do exclusive representation, to have this monopoly over the rule setting, but not have any duty attached to it.
Right. Yeah.
Very strange.
Basically, we built the game. Now you have to go play it.
So why would the Supreme Court not rule in your favor here? What's standing in the way besides Knight?
Yeah. I think that the Supreme Court might just say, we've gone far enough. We've given people the right not to pay if they don't want to be, associated with what the union's doing. We think that maybe it's in the best interests of everybody that this system stays around. It makes it easier for public entities to, negotiate one contract across all the labor force. We're just going to leave that in place. We've given people, who may have objections and we've given them enough of a way out and enough way to say that we're not associated with this union and we're not paying for the political speech of the union.
Maybe you're just a good advocate, because it's hard to see how someone could, I don't care where you fall on the political spectrum or whether you are a hardcore union member or not, it does seem that the coercion of the minority here, especially when you've already given them the right not to pay the union as a function of the impingement, why you could still be forcibly represented by a union when it's not completely necessary. The model doesn't have to look this way. So it's hard for me to imagine if the U.S. Supreme Court does take the case that exclusive representation could stand.
Yeah. It's interesting because, again, I guess going back to the Supreme Court's decisions that talk about exclusive representation, they acknowledge that we don't allow for this in any other context. I mean, this is really a unique thing in constitutional law that this is allowed. Exclusive representation is allowed because the justices have recognized in their opinions that, yeah, this wouldn't fly anywhere else. We basically allow this in the labor context, and we've blessed it. We've given some conditions on it, the duty of fair representation, those types of things. But yeah, this isn't normal. I think that's basically what they're saying.
There's a distortion of some kind in the law here.
Yeah. Yeah. I mean, they even go as far as to say, we recognize the impingement on their First Amendment rights. So
what's the compelling interest from the other side? I mean, how do you argue this? What do you need to coerce a minority to be part of this system?
Well, I think it's because they say there's labor peace. We don't want, all these factions fighting. We want it to be easy for the employer just to deal with one exclusive rep, one union on all these things. So that's largely what they say is the reason for this, that it basically just makes the system run a lot better. But I don't think, especially if you apply like strict scrutiny to this, like that doesn't really fly. Your mechanics running well isn't a higher priority than people's First Amendment rights.
Right. Yeah. The First Amendment is not terribly efficient.
Right. Yeah.
The whole point of it is to get minority interests protected.
Exactly. Yeah. That's exactly why it was set up, so that dissenters and those in the minority would still have a voice and couldn't get steamrolled over.
Yeah. Well, how are your clients doing? This is a waiting game. It may be a little while before they hear back. Are they anxious? Are they excited? How would you characterize them?
Yeah, I mean, I think it's probably the same as anybody waiting for the Supreme Court to decide whether to take the case. Like, they feel that this is their chance, this is their opportunity to really change their circumstance and to really be free from something that weighs on them so heavily. And they want it to be a great decision for everybody, really. They want everybody to have the freedom to choose who speaks for them, who doesn't speak for them.
It's an interesting time in our history. Mm-hmm. When the case started, I recognized that the union was taking some pretty seemingly outlandish positions on Israel.
Yeah.
But since that time, it has become, a far more, it's still very controversial, but a far more accepted view. And then there's actually an all-out war in the Middle East. And all this is happening while they're waiting to get their case addressed by the U.S. Supreme Court.
Yeah, it's interesting. Our clients, even before their case was filed, they were raising the flag on this. They were saying, hey, this is, this anti-Semitism is a problem on campus. And, it was like, okay, sure. And then this resolution came out from their union in the summer of 2021. And it was kind of like, oh yeah, maybe there's something here. And then October 7th happened, a year or two later, where it's just been an explosion of anti-Semitism. And it's been, I just still can't believe the things we're seeing in the United States of America. It's shocking to me. But to show you just one example of how I would say, in our client's view, anti-Semitic their union really is, the university law school had the student commencement speaker, and she went on and adopted the views basically of pro-Palestine and BDS, the boycott, divest, and sanction movement, just went real deep on it, all in on it. Even the university and everyone kind of pulled back and was like, yeah, maybe that was a little bit too far. The union stuck with her and said, nope, she's right on, keep going. That's totally fine.
They're not the only union either. There are unions all across the country who've, in a similar setting, have actually advanced the argument that these sorts of protests on college campuses are part of graduate assistants or graduate students' working conditions, so that not only should they be allowed to do it under the National Labor Relations Act, but that the university should be compelled to bargain over it as well.
Right.
So they're trying to take all of this stuff under their jurisdiction, which is very surprising.
Yeah. And that's the thing, right? Because a lot of people say, well, the union is they're doing their collective bargaining. terms and conditions of employment. And, what they say outside of that, that's just their First Amendment right, their political speech. Mm-hmm. The problem is what we're hearing now is that unions are trying to negotiate into collective bargaining agreements support for BDS stuff and very anti-Israel policy. And so even in the terms and conditions of employment now, in the actual contract, they are bringing in very, very explicit political stances and biases and anti-Semitic policy. And so you can't say anymore that these things are separated. It's just like in Janus. There is no dividing line. You can't draw this line between collective bargaining and political. It's all political. And it is certainly moving that way now in the negotiations into the actual contracts. And I think, again, the Supreme Court back in 1944 and all the way through when it's considered this question could never have anticipated what is going on right now. And I think one of the really compelling things about our client's case, of course, we didn't know about it then when we filed it, but since October 7th in particular, with everything that's come out and the shape that the world is in today, if there was ever a set of facts that crystallized the evil and the horror of what exclusive representation is, it's our client's case. Mm-hmm. Like, this is the moment.
So when do you expect to hear from the U.S. Supreme Court?
Probably either later this year or early next year.
Okay. All right. Where can we go to find out more about this thing?
Well, you can go to fairnesscenter.org and click on our cases page. It's the Goldstein case. You can find all sorts of information there.
All right. Nathan, thanks for coming on.
Thanks so much for having me.
And that's a wrap for today's episode of Disunion, the Government Union Report. We hope you found today's exploration into public sector labor policy both insightful and thought-provoking. Special thanks to all of you for tuning in. If you enjoyed today's discussion and want to stay informed about the latest developments, don't forget to subscribe to Disunion, the Government Union Report, on Spotify or your favorite podcast platform. Your support means the world to us. I'm David R. Osborne, reminding you that understanding labor policy is crucial for shaping the future. Until next time, stay informed, stay engaged, and keep making a difference.